Yesterday, we have completed up to the role of inquiry officer, and now today we will discuss the role of discipline authority and further case study.
Now the role of discipline authority comes on receipt of the inquiry report. On receipt of the inquiry report from the inquiry officer, the discipline authority should read it thoroughly and satisfy himself that whatever has been advised to the inquiry officer, he has complied with. In case he finds that there are certain lacuna, means any witness has not been examined or certain document has not been examined, or there are any other lapses in the inquiry, he should immediately send it back to the inquiry officer to rectify those lacuna and resubmit it. Once he is satisfied that the inquiry report is in order, it means that legal provisions have been strictly complied with. Then he should see that if any dissent note is required. A dissent note means if he is not agreeing to any observation or finding of the inquiry officer, he should record the reason of not disagreement, and once he has completed this, then inquiry report along with his dissent note should be sent to the party charge to submit his defense statement. This will be treated as show cause notice that he has accepted the report of the inquiry officer and has found him guilty of whatever charges and proposed to impose punishment as per legal provision, and before imposing the punishments, the party charge is given an opportunity to submit his defense details. Normally, time allowed is 15 days for compliance of such notices by the party charge, and it should be clearly mentioned in the show cause that in case he does not submit the reply in the prescribed time limit, no further opportunity will be given to him and case will be decided as per legal provision. However, in case discipline authority concludes that the offence done by the party charge is so that he needs the punishment which is not in his competence to impose as per the authority given under RPO rules, the discipline authority should record this in the file and forward it to the competent authority who has the authority to impose that punishment. In this case, normally it is seen that the discipline authority does not mention the type of punishment which is warranted. Here, the advice is given that the discipline authority should clearly write that the punishment awarded, suppose it is removal, should write that punishment warranted removal from service, and as per the authority given in schedule, he is not authorized to impose such punishment, and that is he is forwarding the case file to the competent authority, DSC or senior DSC, or in IG or DG to take appropriate decision in this case. So the initiating disciplinary authority should complete the full procedure. That means that he has read the inquiry report, decided on acceptance of the inquiry report, issued the show cause notice to the party charge, and on receipt of the reply he has decided that punishment awarded is not in his competence, and that is why he forwards the whole file to the competent authority. The disciplinary authority has the liberty to impose minor punishment in case the inquiry has been done under the provision of Rule 153, that is for the major penalty punishment. In RPF rules, it is sufficient to issue show cause notice of 15 days without mentioning the punishment proposed. It means that show cause notice should be issued without proposing the punishment to be given. On receipt of the defense on show cause, the disciplinary authority is at liberty to impose any of the major punishments as prescribed in the RPF rules. The precaution is that while deciding the punishment, the previous bad record and punishment should not be quoted in the punishment order. However, if the previous bad record and punishments have been quoted in the charge sheet, then of course it can be discussed and should be discussed. The disciplinary authority, while imposing punishment, should carefully see the provision of Rule 156 of RPF Rules 987. This provision makes it mandatory of certain punishments. The punishment of dismissal has been made mandatory unless the reasons are recorded for not giving this punishment. So, inquiry officer, so disciplinary authority should apply his mind that why he does not want to impose the punishment of dismissal from service in certain circumstances. The circumstances mentioned in 156 are that for dismissal, if the party charge has been convicted by criminal court, the dismissal from service is required. Secondly, serious misconduct or indulging in committing or attempting or abetting an offence against headway property. Third is discreditable conduct affecting the image and reputation of the force. Fourth is neglect of duty in or likely to result in loss to the railways or danger to the lives of persons using the railway. Fifth is insolvency or habitual indebtedness. And sixth is obtaining employment by concealment of his antecedents which would ordinarily have debarred him from such employment. Then there is a provision of removal from service. The circumstances mentioned are: 1. Any of the misconduct for which he may be dismissed under clause A above. Second is repeated misconducts. Third is absence from duty without proper intimation or overstay beyond sanctioned leave without sufficient cause. Rule 157.3 makes the provision for withholding of increment. In case of withholding of increment as a punishment, the order shall state the period for which the increment is to be withheld and whether it shall have the effect of postponing further increments. Normally, the disciplinary authority commits a mistake here, which are prescribed in Rule 157. So, at the time of taking decision on punishment, Rule 156 and Rule 157 are important for the disciplinary authority to apply his mind and follow these provisions with caution. Now we have Rule 158, where procedure of imposing minor punishments have been prescribed. Minor punishments have been prescribed in sub-rule 3 of Rule 148 and Rule 149. The provision of minor punishment has been given in Rule 158 of the RPF Rule 1987. The minor punishments have been prescribed in Rule 148 and Rule 149. Now the procedure prescribed in 158 provides that a charge sheet should be issued giving the details of misconduct or misbehavior as defined in our RPF rules, for which we have already discussed at the time of discussing the major penalty charge sheet. The rule of conduct are already discussed. Now for minor penalty charge sheet, we have to see that any of the conducts which are constituted as misconduct have been done by the member of the force, then we should mention those facts and circumstances constituting the misconduct or misbehavior right in the charge sheet and serve the charge to the party charge to reply in 10 days from the receipt of the charge. On submission of the reputation, the disciplinary authority has to record the finding on each imputation of misconduct or misbehavior. Here the caution is that the disciplinary authority has to consider each and every contention raised by the party charge in his reply. And the disciplinary authority should explain as to why he finds it that the condition of the party charge are not correct and the misconduct or misbehavior as mentioned in the charge sheets stand good. On taking this decision, he should decide the punishment. Now further precaution of certain punishment has been given in Rule 158.2. If it is proposed to withhold increment of pay and such withholding of increment is likely to affect adversely the amount of pension, or to withhold increment of pay for a period exceeding 3 years, or to withhold increment of pay with cumulative effect for any period, or to reduce him by more than 3 stages in his scale of pay, then an inquiry shall be held, and this inquiry should be done according to Rule 153 of RPF rules. So, the disciplinary authority has the liberty to impose these punishments under minor penalty charge sheet also, provided that then inquiry will be required as far as possible in the manner laid down in Rule 153. Now we come to the special procedure under Rule 161 of RPF rules. This rule provides that notwithstanding anything contained anywhere in these rules, where any punishment is imposed on an enrolled member of the force on the ground of conduct which has led to his conviction on a criminal charge, or where the authority competent to impose the punishment is satisfied for reasons to be recorded by it in writing, that it is not reasonable and practicable to hold an inquiry in the manner provided in these rules. Thirdly, where the President is satisfied that in the interest of security of state and maintenance of integrity of the force, it is not expedient to hold any inquiry in the manner provided in these rules. The authority competent to impose the punishment may consider the circumstances of the case and make such orders thereon as it deems fit. Now, Rule 161 of RPF rules provide the authority for the disciplinary authority to remove or dismiss a member of the force in these circumstances. So far we have discussed the framing of the charge sheet, the role of inquiry officer, the role of disciplinary authority, and all the 3 kinds of punishments for which disciplinary authority is authorized to impose: major, minor, and the special circumstances where inquiry is not required. Now we will discuss appeal and revision. In the appeal and revision, in both the cases, we have to, as a disciplinary authority, examine the admissibility of the appeal. Now, the appeal has to be submitted by the party charged within 30 days from the date it has been served on the party charge. Now, the service of the punishment order is done either in person or through pasting of the punishment order on his last known address at the conspicuous place of the place concerned, or through postal department. The acknowledgement of the postal department of having served the notice is conclusive proof of service of the punishment order to the party charged. So, from that date, if the 30 days have been completed and the appeal is submitted by the party charged, the disciplinary authority has to go through that appeal and find out whether the party charge has given any reason for late submission of the appeal. The date of completion of 30 days will be taken from the date of service of the punishment order, as I mentioned earlier, and to the date it is received in the office of disciplinary authority. As per the RPF rules, the appeal has to be submitted to the office of disciplinary authority. Revision also has to be submitted to the office of disciplinary authority. So, the disciplinary authority has to examine the admissibility of the appeal or revision as the case may be, and then process it. If it is within 30 days, then the disciplinary authority has to prepare the documents. In the document, the first thing, the disciplinary authority has to write the brief history of the case. In this brief history of the case, the disciplinary authority has to explain as to when the first report of misconduct or misbehavior arose and how it was reported to the disciplinary authority, and on the basis of that the preliminary inquiry was ordered, and on receipt of the preliminary inquiry report the charge sheet was framed and inquiry officer was nominated for the inquiry. On completion of the inquiry report, the inquiry report was examined and found that all the legal provisions were complied with in the inquiry report, and on that satisfaction of proper conduct of inquiry, the show cause notice was issued to the party charged, and on receipt or not receipt, whatever be the situation of the show cause notice reply, the decision was taken to impose the punishment of removal, dismissal, or whatever punishment was decided, and this punishment was decided keeping in view the provision of the RPF rules. After that, the charges and statement of allegation given to the charge sheet should be written, and next is the para-wise comment of the para-wise comment on the appeal of the party charge. Para-wise comment means strictly that each para of the appeal should be numbered. If the party charge has not numbered, the disciplinary authority should number each para and then write para-wise comment. The point raised in that para should be replied properly. It is normally noticed that the disciplinary authority do not cover all the paras and points written in the para in the appeal. This makes it difficult for the appellate authority to get the view of the disciplinary authority on certain points raised in the appeal. So disciplinary authority has to be very careful on writing para-wise comments, and then prepare the whole appeal file. As per the RPF rules, Rule 216 provides for the documents to be submitted to the appellate and revisionary authority. So these documents are brief history of the case, charges and statement of allegation, parawise comments, disciplinary case file in original with all its connected papers, service book, confidential roles folder. These are the documents which should be mentioned in the forwarding letter by the disciplinary authority and submitted to appellate authority. In case of revisionary, in case of revision, the same procedure has to be forwarded. In case of the revision, the disciplinary authority should follow the same procedure. Only thing is that he has to mention that in brief history of the case that this case was decided by the appellate authority on certain whatever letter number, date, and served to the party charge on so and so date. So the proof of serving the appellate order should also be given in the forwarding file. And similarly, while forwarding the file to the appellate authority, the proof of serving the punishment order should be given to the appellate authority. So, the disciplinary authority has to line up these documents and submit to the disciplinary and revisionary authority as the case may be. And appeal lies to the immediate superior officer who has placed the party charge under suspension. The appeal lies to the authority immediately superior to the authority imposing the punishment. There is one exception in the rule that that the appeal against the order of Principal Chief Security Commissioner lies to the DGRPF, and the appeal against the order of DG lies against the central government. The appeal is submitted by the party charge in his own name. Any appeal forwarded through or countersigned by legal practitioner or defense counsel or a friend is not entertained, and such kind of appeal should be returned to the appellant with the direction to submit it under his own signature. The appeal should be addressed by the party charged to the authority to whom the appeal lies. For example, ASC has given the punishment, then appeal lies to the DSC or senior DSC. So the appeal should be addressed to the senior DSC through ASC. And then this appeal should contain all material statement, arguments on which the appellant relies. The appellant should be cautious that he should not use any disrespectful or improper language or irrelevant allegation in his appeal, and the appeal should be complete in itself. Like he should write that he has been given the charge sheet, so punishment order, and then write on the documents which he has seen or got in the inquiry. The party charge, if he is not in the service, still has the facility to submit appeal, and it should be submitted through the authority who has impose the punishment to the authority who has the appellate authority powers. We have the provision of withholding of appeals under RPF Rule 215. The appeal can be withheld on the following grounds: if it is appeal against an order from which no appeal lies. For example, the final authority has given the order and there is no provision of above any authority to consider the appeal. Then if this type of appeal is received, then disciplinary authority can withhold this appeal. The appeal which does not comply with any of the provision of Rule 213 is not allowed. If the appeal is not submitted within the period specified in Section 9, that is the rule of 30 days, and the cause has also not been explained for delay beyond 30 days, then this kind of appeal is withheld by the concerned authority. Then if it is a second appeal where original appeal has already been decided by the competent authority. Now, what is the action to be done by the disciplinary authority when he withholds the appeal? Then he should inform this fact of withholding. Then he should inform this fact of withholding the appeal to the party charged within 30 days from the date of receipt of the appeal in his office, with reasons thereof. The appellant has the liberty to submit the appeal directly to the appellate authority in case of withholding of the appeal by the disciplinary authority, and then this facility is available to the party charged for 30 days from the date he receives the order of withholding the appeal from the disciplinary authority. There is a further provision for the disciplinary authority to submit quarterly statement of withholding of such appeals to his superior authority. Rule 219 of RPF rules provides the provision of revision. It provides that when an enrolled member of the force whose appeal has been rejected by a competent authority may prefer an application for revision to the next superior authority, the power of revision may be exercised only when A. In consequence of some material irregularity, there has been injustice or miscarriage of justice, or fresh evidence is disclosed which could not be produced or was not available at the time of passing of the impugned order. The procedure for submission of the revision is the same as mentioned for appeal. Now, in case of appeal and revision, the authority is given to appellate and revisionary authority to enhance the punishment. Now, for enhancing the punishment, these authorities are required to issue show cause notice to the party charged, giving all the details of facts and evidences, as to why uh, there is a need for enhancement in the punishment. On receipt of the reply from the party charge, the appellate or revisioning authority can enhance the punishment. Now, if this punishment has been enhanced, then the authority enhancing the punishment becomes the original discipline authority, and then the party charge gets the opportunity to appeal in revision against those enhanced punishments. Of course, the limit is that where there is no provision of appeal, then appeal will not lie, and the appeal will not lie to this any authority. For example, if the decision is taken by DGRPF, the appeal lies to the central government, and then there is no authority above central government, so revision will not lie. In case of decision is taken by the central government, then there is no further authority to file appeal or revision, then these opportunities will not exist. There is further provision of suo motu action being taken by authority superior to the disciplinary authority to call for the record of any inquiry and revise any order made by the disciplinary authority. The appellate authority and revisionary authority have the power to call for the file, see the details, and take any of the decisions of confirming the punishment, modify the punishment, enhance or decrease, or set aside the punishment order. These authorities have the power to impose punishment also where no punishment has been given by the disciplinary authority. Further, these appellate and revisionary authorities have the power to remit the case to the authority which made the order, or to any other authority directing such authority to make such further inquiry as it may consider proper in the circumstances of the case, or pass such order as it may deem fit. There is a provision of appeal against order of suspension also in the Appeal Rule 211. However, there is a time limit for such action. Time limit is prescribed as 1 year from the date of the order of the disciplinary authority. The time limit for disposal of appeal or revision has been provided in Rule 220. The time limit of disposal of such appeal or revision has been given 3 months from the date of receipt of the appeal or revision in the Office of Disciplinary Authority. There is a provision of time limit for disposal of appeal or revision in RPF Rule 220. The time limit has been given 3 months from the date of receipt of the appeal or revision by the authority competent to decide it. There is a difference here that earlier we saw that the time limit starts from the appeal received in disciplinary authority office. Now this time limit starts from the authority competent to decide appeal or revision. There is a further provision under Rule 220.2 that if more than one enrolled member of the force are involved in the same case and they are awarded punishment simultaneously, then if one gives the appeal and others do not give appeal, then this fact will be noted by the competent authority. In case one files the appeal, then others should also be informed that one has filed the appeal and you wish to file appeal, you can file appeal. And in case all the party charges are submitting their appeals, then those appeals should be forwarded together. Though the para-wise comments and all documents can be separately sent along with the forwarding note, but then this fact should be recorded while forwarding such appeals. All the members of the courts, gusted and non-gusted, should note that adhering to the time limit in processing discipline and appeal cases is a mandatory provision, and delay of not following the time limit will constitute misconduct, and the concerned officer can be taken up under departmental rules for this misconduct. There is a provision also for taking up the concerned officers for delay in decision making in vigilance case also. So the officers concerned, whether gusted or non-gusted, should know and note down the time limits for their activities, actions, and adhere to it, and in case of any difficulty should inform to their superiors so that they can be properly guided and the action is taken within time limits, or else the concerned authority is informed so that the person charged of delay is exempted from that charge. In DR case, the following points should be kept under consideration. Number one, no double jeopardy should happen in any case. For example, if a member of the force is already undergoing punishment and his punishment is to be enhanced by the competent authority, the earlier punishment should be withdrawn first, and then show cause notice be given as to why his punishment should not be enhanced. Number two, the type of punishment should not be mentioned in the show cause, as it might show that the disciplinary authority has already decided that what kind of punishment he is going to give to the delinquent or charge officer. Show cause notice should show that the charges against the charge officers have been proved, and the charge officer should show cause as to why the punishment prescribed under the rules should not be given to him. Number three, the disciplinary authority should carefully see that the document indicating the offence done by the charge officer is dated prior to the punishment order. It should not happen that the document proving the offence is issued later to the punishment order. This mistake may happen due to verbal communication of the order by the senior officers to the junior officer. So the junior officer who is working as a disciplinary authority should be careful that the documents quoted by him in the disciplinary order are properly dated. That means that whatever document he has relied upon should be on the record prior to issue of his disciplinary order. Number 4, the rule 161 should be used when the charge officer is not cooperating in the inquiry and disrupting the process. B. Threatening the witnesses. C. Resorting to disorderly conduct in inquiry. It means that the use of Rule 161 should normally be not utilized when the charge officer is cooperating in the inquiry and there is no circumstances to say that the normal inquiry cannot be held. If the normal inquiry can be held, then it should be it means that when the normal inquiry can be done under Rule 153 of RPF rules, then Rule 161 should not be resorted to. Normally it happens that when a member of the force commits any offense in public domain and it is shown in the media, print or electronic, then there is a pressure on disciplinary authority to take prompt action against the charge officer and 161 is resorted to. But subsequently, the honorable courts are insisting that the charge officer should be given an opportunity to defend himself and the inquiry should be done under Rule 153. So, we have to keep patience and resort to the procedure under 153 unless it is so compelling that the inquiry has to be done under, action has to be done under Rule 161. The circumstances of resorting to Rule 161 have already been explained by DGRPF and one should be careful in implementing those instructions. The disciplinary authority should not be the disciplinary authority when he himself is complainant. Similarly, appellate or revisionary authority should not pass the disciplinary order if the offense has against them. It means that if the charge sheet issuing authority, appellate authority or revisionary authority are part of the complaint, then they should not issue any disciplinary order. In such situation, the officer who has complained should record on file that since he has been the complainant, the matter should be decided by the next higher authority who is not part of the complaint. When there is a charge on the charge officer for absence from duty, then the reason of absence should be carefully examined by the disciplinary authority. It has been noticed that in a case when the charge officer was medically decaterized but he was removed from service because he absented from duty for long. Now when there is already a reason recorded in the government records that he is absenting because of certain sickness and he is getting treatment whether in railways or outside the railways, and it is not possible for any human being to come to duty in those difficult situations, then the disciplinary authority should not impose any punishment in such circumstances. He should wait for his proper treatment and take the decision when the situation is mature. The other important point should be kept in mind that departmental proceeding should not be conducted by an officer lower in the rank than that of an officer who conducted the preliminary inquiry, that is fact-finding inquiry. For example, if an ASC has been given the task of conducting fact-finding inquiry or preliminary inquiry, then the inquiry officer should not be lower in rank than ASC. While referring any instructions, it should be carefully seen that that instruction has been issued before the commission of the offence. It should not happen that the instruction for certain actions have been issued later and the charge sheet says that this instruction has not been followed by a person on earlier date. It cannot happen that a person can do any violations of any order which has been issued subsequent to his act questioned upon. When the disciplinary authority finds that the punishment needed in a particular case is not in his competency to impose, then he should forward the case file to the competent authority without mentioning that what kind of punishment is to be given to the charge officer. For example, if ASC finds that he is not competent to remove head constable from the service, then he should forward the case file to senior DSC without mentioning that the punishment of removal from service is required in this case. Otherwise, it is treated as that the next authority is being influenced by the junior officer on the quantum of or type of the punishment. The competent authority should be free to decide the type of punishment he wants to give to the charge officer. It has been noticed that sometimes the charge sheet has been issued without conducting the fact-finding inquiry, that is preliminary inquiry. In RPF rules, the fact-finding inquiry is essential before issuing the charge sheet. So, one should be careful that the preliminary inquiry is conducted before issuing the charge sheet under Rule 153. The disciplinary authority should carefully read the inquiry report of the inquiry officer who has conducted inquiry under Rule 153 of RPF rules. Once he reads the report, if he agrees that the inquiry officer has properly conducted the inquiry following the procedure laid down in RPF Rule 153 and he has not left out any evidence on record, then he should issue the show cause notice to the charge officer. It should not happen that the inquiry officer has not properly examined the evidences and in some time he has recorded that either the charge is not proved or partially proved. Then the charge officer submits his defense statement. After that, the disciplinary authority should not say that he is not agreeing with the certain points of the inquiry officer. This job the disciplinary authority has to done prior to issue the show cause notice. So, disciplinary authority should record his disagreement on any point of the inquiry officer before issuing the show cause notice to the charge officer, and he should forward his disagreement note along with the inquiry report to the charge officer. Once the charge officer submits his reply to the show cause notice, the disciplinary authority should decide the case. He should not resort to refer this case on receipt of the reply of the show cause notice of the charge officer to the inquiry officer. This indicates a lapse on the part of disciplinary authority for not having read and agreed to the findings of the inquiry officer prior to issue of show cause notice. So, disciplinary authority should be doubly sure that he has seen and examined and agreed to the inquiry report of the inquiry officer, and then only he has issued the show cause notice to the charge officer. Prior to issue of the show cause notice to the charge officer, the disciplinary authority has authority to refer back to the inquiry officer for any clarification on any evidence which the inquiry officer has left out in his discussion. Taking action under Rule 161 of RPF rules is based on three grounds. One is conviction on a criminal charge. Second is when it is not reasonably practicable to hold an inquiry in the manner provided in these rules. Number three, where the President is satisfied that in the interest of security of state and the maintenance of integrity in the force. Out of these three conditions, we should be careful that in case of taking bribe or doing this kind of activity by an individual member of the force is not necessarily false under the provision of Rule 161. When there is a conviction in a criminal charge by any court, it is a very clear ground under Rule 161.1. So, disciplinary authority can surely take action against the charge officer on this ground and remove or dismiss the charge officer without conducting inquiry under Rule 153. However, while taking the action under Rule 161.2, regarding the reason that it is practically not possible to hold the inquiry, it is a very difficult task. Normally the high courts are not agreeing to not following the Rule 153 for conducting inquiry. They are insisting that in case of the member of the force taking bribery or doing certain indecent acts which are individual to him are very much possible for conducting inquiry. So, disciplinary authority should very carefully examine that when the inquiry is possible, then 153 should be resorted to. DDRPF also has clearly issued the instruction that when the charge officer is not cooperating in inquiry and disrupting the process, one should resort to 161 when it can be clearly written that the inquiry, the charge officer himself is not cooperating in the inquiry, so it is practically not possible to conduct inquiry against him. But where he is not behaving like this, then inquiry has to be done. Secondly, when the charge officer is threatening in the inquiry, then you can record with evidence that he has threatened the inquiry officer or he has done something where witnesses are afraid of participating in inquiry, then you can record this in the file and take action under Rule 161. If during the inquiry, say under Rule 153, the charge officer is behaving in a very disorderly way, is sort of abusing the witnesses or inquiry officer, one can record the reason for it. But then straight away going under Rule 161 should be avoided. When it is said that 161 is being resorted to for national security, then one should be very clear that what kind of act is actually constituting the threat to national security. National security is a very serious matter where the district authority should see that what kind of actions of the charge officers are resorting to say disruption in the cooperating or working under the influence of the foreign powers or the foreign elements or some intelligence agencies outside India. This kind of activity if is resorting to and there are evidences on record, only then there is a question of national security. Similarly, the issue of maintenance of integrity of the force, one should see that what kind of activity the charge officer has done which has created the disruption in the mind of the member of the force. So if he is not doing these kind of activities as per on record, then we should not resort to Rule 161 of the RP Rules 1987. The golden rule is to follow Rule 153 for major penalty charges, major penalty punishments.
Thank you for hearing this long session patiently. I hope I had made some value addition in the procedural appeal of DNAR.